Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers, with your hosts, Ben Siders and Kirk Damon. This episode is brought to you by someone who knows someone you know. You're next.
And welcome back into Lawyer's Guide to the Galaxy, episode 11, with your hosts, Ben Siders, that's me, and the other guy here is Kirk Damon.
That's Kirk as in the captain of the Enterprise.
This is episode 11, and we are going to talk about urban legends, and we should say a special shout out to those of you joining us for the first time. Kirk, we went to Startup Connection a couple weeks ago when you all listened to this, and met some interesting people.
Yeah, and hopefully all the people we told that should listen to this are actually listening to it. If they're not, then apparently they didn't listen to us.
Yeah.
And maybe that's why they're not listening. Wait, that's starting to sound really circular. Sounds kind of like our intro, actually, to this episode, just being kind of circular reference.
Yeah, it does. So our topic today is urban legends, and we're going to talk about two different aspects of this. One is who owns rights to sort of these organically developed collaborative projects that just sort of, I don't know, they crop up on the internet kind of on their own.
Yeah, they just appear and then take on a life of their own. I think because either somebody creates a fun universe that isn't really a property. And we've talked a lot about this show previously about the idea of like fan fiction, wanting to sort of jump onto known properties, work with things that are out there. I think a lot of the urban legends that you sort of encounter are things where they really grow organically. There's no intention of making a property in the beginning of this, yet people want to join it and want to be part of sort of the same movement.
Yeah, certain things just seem to capture our imaginations. We're going to talk about Slender Man in a little bit. And the other topic we're going to cover is debunking the flip side of the urban legend, which is, I call it internet folklore. It's just things that you see people say all the time online about the law that's just wrong, or at least less clear than they make it seem.
As we commented about it, it's what we get to do in this one is actually have fun being Mythbusters,
yes,
which I think is a show that we're all addicted to and everything else. Unfortunately, we can't build medieval weapons, and we don't have an explosives expert, so we can't necessarily do that. We joked about the idea I was going to try to show up with a thermal detonator, but I don't even know what one sounds like, so I'm not even sure we could edit in a soundtrack explosion.
That's an idea for a future show, bring in an explosives expert. I'll define some topic that requires an explosives
That would be fun, yes.
All right, so internet urban legends, we'll start with that. It's sort of a combination of, conventional urban legends, folklore, and just your garden variety hoax. And it can be hard to separate, I think, one from the other. So the Slender Man I mentioned in the introduction is the main example of this. So by way of background, if you've never heard of it, Slender Man is a fictional, paranormal, Lovecraftian type of character.
I think very Lovecraftian is a good way to describe it.
He was created in the Something Awful internet forums. That was a thing. It may still be a thing. I don't know. But it was part of a Photoshop contest to make, everyday photos have some element of the paranormal to them. And I don't know who did it, but somebody Photoshopped into these black and white photos of just like kids playing on a playground, this really tall, like 10-foot tall, faceless figure in the background wearing a suit. And in some pictures, he had like tentacles coming out of him. That's the Lovecraftian aspect of it. And it just sort of took on a life of its own from there. For whatever reason, this character captured people's imaginations and just blew up into a whole mythos unto itself.
Yeah, I think a lot of it is, and it's, we're used to sort of seeing this. I think there's a real desire for there to be sort of the supernatural universe beyond our universe. I mean, regardless of whatever you think in conjunction with there being other universes or there being things we don't understand.
It appeals to our sense of wonder. And I mean, when you're first reading a new book or like exploring a new like property, a new universe, and you just don't understand what the heck is going on, that's when it's the most fun.
Yeah. And I think a lot of science fiction, a lot of sort of things, really sort of focus in on that. I mean, you joked about it. You recommended to me a few weeks ago that I actually read Snow Crash, which I did finally read in conjunction
with Stranger Things.
And I'm watching Stranger Things, which I just got season 1 on DVD, so don't spoil it for me. I haven't seen it yet. I need to get an excuse to sit down and actually binge watch it. But I think one of the things like in Snow Crash is when you like read through it, there's this huge discussion of what all this history means. And I think there's a part of us that kind of wants that to be true, that it is this kind of cool extra thing that's out there. And it's a real common theme throughout, I think, a lot of science fiction, throughout a lot of just generally fictionalized works. This idea that there's something like beyond what we can see and that somehow we end up getting exposed to it. And part of this, I think, kind of tries to make that real, even if it is something that's just simple, even if it's something we know is fake. And that's potentially where the sort of Slender Man thing came from, is we have sort of the basic idea of are there aliens out there? Are there supernatural out there? And so what we have suddenly is somebody basically creating these photos, which should be evidence, which should be something we can see beyond just a fiction, that we kind of look at and say, hey, what if this was real? And now we want to make it real. So we actually go and expand upon the idea of it being real.
And sometimes it's much more elaborate than just a photo. So do you remember the fake alien autopsy video from the 90s?
Oh, yeah. And that's I think the great thing about the fake alien autopsy video is it's admitted that it's fake. Everyone knows it is fake.
But I got in so many arguments with X-Files fans who insisted if it wasn't real, then it was based on real footage somebody saw at some point. I'm pretty sure that was another Roswell alien situation. Yep. But it doesn't have to be internet videos either. I don't remember I think the 95 video I found online, the alien autopsy one, but like the Bigfoot Patterson video, I mean, that was recorded in the 70s?
Well, let's go all the way back. And what about War of the Worlds? That was a radio show. That's the equivalent to us, coming out here and saying, hey, guess what? Aliens are invading. And, people who tuned in the middle of the presentation, not realizing that it was a work of science fiction and thinking, tripods from Mars had arrived on Earth and were destroying things.
Well, let's talk about Slender Man. I think that's probably the most, it may be the most well-known internet folklore right now. There's lots more out there, but that's the one that's probably the most interesting because, one, it itself borrows from a pre-existing mythos, the Lovecraftian horror universe.
Yep.
And the folklore around it has really taken on a life of its own to the point that, if you haven't heard about this, there have been a number of violent incidences, mostly involving teenagers, and the most famous one probably being a couple of 12-year-olds in, I think, Waukesha, Wisconsin, tried to murder a classmate to appease Slender Man because they'd read online that if they didn't, he would come murder their family.
I mean, I think the biggest concern here you bump into is the everything on the internet is true phenomenon, or the because I read it on the internet, it's true phenomenon, that, we've reached the point, and I remember hearing a great quote actually from somebody where they said, what's the difference between generations? And they were talking particularly about legal research, but I think it's a general sort of phrase that's really useful. And the comment with it is they said, you look at people who are in the Generation X or sort of older than that, and they say the internet is a tool for research. You talk about people who are sort of millennials or later, and the internet is the tool for research. And I think that dramatically sums up the way we use the internet, is we're really reaching this point that the internet is this sort of monster source of information. And one of the concerns with it is separating the real from the fictional from the non-fictional.
That's where you run into the sourcelessness problem, where you find stuff online and sources are almost always either made up, unverifiable. It's really difficult to know where things are coming from and how much stock to put into it. And if anything, that's one of the reasons why I think people trust Wikipedia. It's such a big community of people who care so much about it being accurate that when I read stuff on there, I usually just start with the assumption it's probably reasonably correct, but also it's usually sourced. There's usually footnotes you can go find out where the information is coming from.
Although I do think a lot of it depends on what it is you're looking up. I mean, if you want to look up what is the chemical composition of water, yes, it's probably accurate. Yeah. If you want to look up what happened yesterday on some famous person's Twitter account, then it may not be.
Or any major political candidate's Wikipedia page is full of truths and half-truths. Well, let's talk through Slender Man. So this started on the Something Awful forums with somebody taking, I think, vintage photos and photoshopping something into them. So right away, we have a potential copyright infringement. We're here again, yet another copyright issue.
Yep, we seem to be bumping into this a lot. And interestingly enough, part of that is because I think copyright in many respects pervades our lives. I mean, we've talked about it, we sort of hinted at it before. Copyright covers so much of what we do, and particularly when we're talking about anything creative, any kind of creative works, which is what it's designed to protect, we bump into copyright a lot, just as we get into anything associated with geek culture, because in some sense, geek culture has a fictional component.
Well, I think most people probably, it's the easiest IP to make. Patents, you have to get a patent application on file. Trademarks, you have to offer or sell something in commerce. But copyright, you sit down and write an email, there's probably some level of copyright in whatever you wrote down.
Well, there is. I mean, by definition. As soon as it's fixed in form.
Yeah, so it's the easiest to make, and it's probably why it comes up so much. But once you Photoshop Slender Man into some antique photo, have you infringed any copyright rights in that photo that belonged to whoever took it?
Yeah.
Probably.
I mean, there's definitely a possibility as to what it is. I mean, you presumably have made a copy of the photo in order to be able to do your Photoshopping into it. Now, being an antique vintage photo, the copyright may very well have run already in conjunction with this photo. Yeah. I think that's a lot of what we'd be getting into in conjunction with this.
Just say the copyright rules don't apply the same to everything because there have been multiple versions of the Copyright Act over the year, the most recent being 77?
late
70s, basically. And so things before that are covered in some respects, but not all the aspects of the new law apply to previous things. In fact, there was just a case out of Florida. I think the Florida Supreme Court issued a ruling that certain copyright matters that were previously left to state law, which maybe sound weird, were not copyrightable. So I forget what exactly it was. I think it was...
it was something to do with pre-1970s music rights, if I remember correctly. And I'm trying to remember exactly which band it was. Yeah, that we should probably put something in the show
protection of sound
notes.
recordings is weird, and it changed in the 1970s Act, and before that it was state law, and so it's kind of a mishmash. It's the further we get away from that, the less it applies to things. But there's a lot of oddness. What was it we were talking about? That one Christmas movie that they forgot to renew the copyright on. So
It's a Wonderful Life.
Yeah, it gets played a million times every year because I forget if it's the broadcast rights or one of the sets of rights wasn't properly renewed. So
yeah, and there's again, I think the thing to keep in mind with it is that when we're talking about copyright, the copyright has changed and the coverage of copyright has changed over the years. We've touched on this before. So when we're talking about, do you infringe a copyright in this, particularly when we're talking about like you're using a vintage photograph, vintage has a lot of meaning. Are we talking about a photograph from, silver plate negatives from 100 years ago? Or are we talking about a vintage photograph from, somebody's Kodak Instamatic that was taken in the 1970s, which, let's face it, not under today's digital, camera rules is about as vintage as it gets. I mean, It still used paper. I mean, my goodness.
Oh yeah, or Polaroids. I got a whole box full of Polaroids somewhere in my parents' basement. Okay, so but modifying the photo, you're reproducing it obviously because you're posting it online.
Presumably you're reproducing it.
You're displaying it publicly because you're posting it online. You're distributing copies because you're posting it online, and then. Are you preparing a derivative work? Are you modifying it enough just by photoshopping in this creepy dude to qualify as a derivative work, or is it just a reproduction?
Well, it's definitely, I think, a derivative work in some form. I mean, obviously you have a reproduction, but you have altered it. Yes, all you've done is add something in. You haven't necessarily changed the subject matter, but I think you can still say it's a derivative work. When we get into it, there's also the level of what level of derivative work. Is this a derivative work where, yes, it's subject to its individual copyright potentially because you've added something to it, but it's still subject to the underlying copyright, or is it something where we bump into the level of a transformative derivative work where really you've created something wholly new? Even though it is based upon the original, it doesn't qualify as a copyright infringement. It's effectively a fair use under what's called transformative derivative work.
And that's probably what the authors of these things care about the most is do they acquire any rights in the new stuff they've added? And the added Slender Man depiction, I mean, standing apart from the photo should be copyrightable to the extent a copyright could exist in it. But is there any copyright in the photo itself as modified with the Photoshop?
Again, I think there probably is, because the fact of just how you did it, you probably had to do more than just add in Slender Man. I mean, people who do decent Photoshop work and stuff like that, you have to add in shadows.
Particularly for a vintage photo where the quality of the picture is different and you got to make it look uneven and add crackling and stuff like that.
Yep, and you got to make sure that it actually fits as to what it is. And one of the common ones they always talk about with Photoshopped images is people forgetting to add shadows.
Oh, yeah.
Or, messing up because they have, some indication of light sources in the wrong place. I mean, that's a really common thing I think you get into with Photoshop photos. What I think is really interesting is we talk about the idea of, vintage photos and making these changes. Obviously, this is something when we talk about photoshopping images, it used to be kind of, hey, you had to know how Photoshop works, you really had to do this. Let's face it, the iPhone 10, we've got components coming in here which are designed basically to do this. I mean, they advertise them. So now we're getting really interesting as to, hey, could you actually be potentially using, a modern device that basically is doing this stuff for you, that's fixing these kind of problems. Now we get into the, hey, how much of this did you actually add, and how much of this is essentially just a machine reproduction?
You made an interesting point about the extent of the copying for how we think about derivative work. So, and I think I kind of, this isn't the legal framework, but it's how I conceptualize when you modify something else that belongs to somebody else, like a photo like that. So if you're making minimal changes, touching things up, maybe here or there, altering the color, converting to black and white, to me that's not really usually a derivative work. It's just a garden variety reproduction of what's already there.
Technically it probably still is a form of a derivative work, but effectively it's still a copy.
But I think to be a derivative work within the contemplation of, it's called Section 106, but it's basically the rule that says that the author of the original is the only person with the right to make derivative works. Usually the new work has to be separately copyrightable or contain separately copyrightable material. So you've got to have at least enough you've added to it to add separately copyrightable ideas, which the Slender Man character clearly is. But if you modify it enough, you go beyond just derivative work and into, it's basically a whole new thing. Let's get you more into, we call it fair use, but basically it's radically changed so much that it's not really derivative of the original anymore. It's wholly original.
Yeah, again, we use the phrase transformative derivative work or transformative fair use a lot of times to refer to these kind of things. And basically it's saying, yes, arguably there's some copying which occurred here in order to do this, but what you did is create essentially a wholly new work out of this, which really is its own expression, has nothing really to do with the original, and what does that mean? And one of the big problems I think you get into a lot of times in the law and a lot of these questions is, where is the line between a derivative work and a transformative derivative work or a transformative fair use? And I think it's one of those things that's just very, very hard to pin down. I mean, it tends to be a case-by-case basis, tends to be specific, and there's just no good, easy way to determine what it is. And, that's, again, I think this is a value of sort of, going through these types of analysis and looking at this type of stuff. We're talking about something in conjunction here with the Slender Man story, with, a story which is wholly fictional, which was made up in conjunction with this, and then became even more fictional and even more relevant. Do we have a transformative fair use that came in someplace after the original photos?
I'd say we probably did because, so you have the photos, which is just people photoshopping stuff. Yep. That's straightforward enough. But then you have the other people who saw these and, it captured their imaginations, like I said before, and they started to write background material. They started to develop this character. And so now you've got the photo, which a whole separate set of issues applies to that. But now you've got person B who comes along and doesn't know how to Photoshop anything, but they can write. And so they make up a background for the character and these the internet folklore about him that inspired these kids to commit crimes. Do you what's the extent of protection or rights that person B would have, and does person B need any permission from person A? This is kind of our Glorfindel discussion from last time, almost, right? Like, we're taking this one little piece and then expanding it, but is it really based on the original other than what this character looks like? We're just kind of making up all this background stuff that's really got nothing to do with the original work. Yeah,
and I think the other thing with it is that you look at it and say, so using the examples like character copyright, which again we touched on with Glorfindel, we have a character that has no background. I mean, at this point in time, it's literally just an image. It has nothing as to what it is. It just appears in an image. It was entered in a particular contest. Can that be infringed by sort of expanding upon it, particularly where the expansion upon it, its sole reference in many respects is that it's the Slender Man, which may not have even been a name that was given to it by the original author.
Tacked on by somebody else later. I haven't looked into it closely enough to know. But it's an interesting point. I think character copyright probably doesn't really exist for just a depiction in a photo like that.
Well, I mean, most of the times the court has said you sort of need something beyond it. I always kind of put it as it sort of needs a personality.
Yeah.
At the same time, they have found character copyrights in potentially very not well described characters and other things. A lot of times all it takes is a name, and that's why I kind of focused it on the Slender Man name. And maybe there's something to it. Who gave it the name? Who gave it the name Slender Man? When did that catch on?
Well, then we talked about this on the way over. I've always wondered if the Enderman from Minecraft was related somehow, because it kind of looks like it's taller, it's got really long limbs, it's kind of creepy and ethereal.
Although it does occupy the end, which presumably is where it gets the name Ender from.
But I mean, Enderman, Slenderman, it's close enough. I don't know. I've always wondered if that was connected somehow. But Minecraft may have come out early enough that's not inspired by. Who knows? Another possibility, so person B, writes some narrative work, and then person C, say, expands on that. So person A says, oh, this is called the Slender Man, and he's from, some paranormal universe. And then person C takes person B and the stuff that they've written and expands upon that further. Now, here's the interesting question. Can person C do that? And that's a tough one, right? Because we're back to the idea to expression dichotomy we talked about, probably a couple months ago now. But copyright protects the expression of an idea and not the idea itself. Yep. So what is the idea behind the Slender Man? What's this creepy, ethereal creature that sort of appears in the background of photographs and is just weird. That's not much of an idea. That basically describes the vast majority of Lovecraftian inspired horror work, right? So does person C by expanding on person B's narrative really infringe anything, or are they just re-expressing a similar idea? It's a really, really fine line.
Yeah, and I think that's the takeaway potentially in conjunction with this when we're talking about these idea of sort of these organic urban legends and who owns rights in these, is this is an incredibly difficult question.
Well, it's going to become relevant someday because at some point somebody will want to make a movie about this, and who owns the rights to these characters and these ideas, if anybody?
Yeah, and I think that's the thing is you may be talking about a large number of rights holders. You may be talking about a large number of rights holders who don't necessarily know what rights they hold, and you may be talking about a large number of rights holders whose rights are dependent upon the rights of others as well. When we start talking about these kind of things, that's where I think you get into, a discussion of these kind of things. Now, can you do a documentary in conjunction with the Slender Man? Yeah, you can. That's perfectly acceptable.
I think HBO did one. It was about the murder or the attempted murder in Wisconsin specifically.
That's perfectly acceptable because at that point in time, we're not using the mythos, we're reporting news, so to speak.
Well, this is where people often, not often, I shouldn't say, but people sometimes question these doctrines and ask, why do we care so much? What's the big deal? We talked last week about law school exam questions that raise these tangled fact patterns, and we've said on here before, there's technical violations, but in business practice, most of these things are never going to be enforced, and that's true. But when it matters is when somebody else shows up and they have found a way to make a whole lot of money off of your idea. Like I said, a movie studio is going to want to make a Slender Man inspired movie at some point. Maybe it's already happened for all I know. And that's when it really matters, because if you're the movie studio, you've got to clear this idea. You have to make sure that you don't have some person sitting out there on the internet laying in wait who's just going to come sue you and say that you infringed their copyright. Yeah,
and I think that's the sort of takeaway from this. And I think one of the things, and this potentially leads us into our next topic, which is about internet urban legends and IP urban legends, is there isn't an easy answer to this. And I think that's, again, probably something you guys have already heard repeatedly on this show.
Yeah, there's an easy answer. These would be short podcasts.
Yeah, they'd be very short podcasts, but it's also, and people talk about, why they hate attorneys because they can't give a straight answer. Well, part of the reason is because there isn't one. These are complicated issues. They involve a lot of different interactions, a lot of different questions. What does that mean? And unfortunately, and I think that leads us into our next topic in conjunction with this, which is internet IP legends. A lot of times people do try to reduce IP to relatively straightforward rules.
Usually unsuccessfully.
And almost always unsuccessfully. I always joke about it where it's and I said, the biggest thing I always hate is I'll watch, like some of these, political news pundits or something along those lines. I'm like, let me simplify it for you. And I always said, let me translate that to, let me make it wrong for you.
Well, let's run through some of these. So I think the one that I hear the most is the poor man's copyright, where
poor man's patent. I hear it the same way.
I wrote it down and I sent a letter to myself, so now it's copyrighted. Well, I mean, I guess that's true. It's copyrighted, but not because you mailed it to yourself, because you wrote it down.
Yeah, it's because you wrote it down. That's actually what makes it copyrighted. You fixed it in form. So therefore,
all the mailing does is give you a date. It's evidence, basically.
Yeah, and that's the thing. Is basically what the poor man's copyright or poor man's patent, where you hear this idea of I'm protecting something by basically doing this. The idea is that the date is definitive. We know what the date is because the U.S. government has verified it by the postage stamp or by the postmark. The problem with this is ultimately what it is evidence. What you're also going to have to do is open that envelope, and somebody's going to have to testify as to what was in the envelope, and that was what that date was. That was what the postmark said associated with the date. One could also testify that I have this piece of paper that I wrote it down on, which has a date on it, and I put the date that was the actual date on it.
Yeah.
It's the same level of evidence in many respects.
It's just a matter of how persuasive it is. Obviously, the postmarked envelope, the jury is more likely to say, okay, well, I mean, you have a postmarked envelope, so that must be the date, as opposed to, do you remember correctly? Did you make this up? Are you lying? And patents are a whole different issue because it used to probably matter, but with the America Invents Act, now it's a first-to-file system. Yep. So the fact that you had possession of the idea back whenever you mailed yourself, not as relevant as it used to be.
Yeah, there's still some requirements as first to invent, and there is the idea of derivative work that somebody actually derives their, invention from something you had, so you can prove that they had it beforehand. Not as big of a deal. And interestingly enough, the United States Patent and Trademark Office actually effectively used to have a poor man's patent, which was the statutory invention disclosure, SID. And what the SID was basically a way for you to say, hey, look, I don't want to apply for a patent, but I'm going to give this to the patent office to prove an invention date. And that was definitive. That actually was the poor man's patent way of doing it. Basically what you did is you burned the bridge by pointing out you had it, by them then having reference to it that was definitively a date.
Well, there's a lot of fair use mythology too. So I'm just going to run through these. Okay.
Fair use mythology is probably, I think, the biggest internet urban legend. And just to point out, to say in the beginning, we've touched on fair use repeatedly in conjunction with this. Fair use is a balancing test. It's something where there are numerous criteria you have to go through in every single cases. There are no per se rules of fair use. What the internet loves to do is come up with per se rules of fair use.
Okay, so I've seen if you use 200 words or less of of a literary work, then that's okay.
No.
No, not correct. It might be. It might not be.
Yeah.
If the literary work is 201 words long, you've infringed almost the entire thing. Yeah.
There's cases that have violated for 3 seconds, 3 words, stuff like that.
Oh, and music especially. I mean, sampling is a whole separate thing. Okay, similarly, if you use 10%, I've seen the 10%, 20%, 30%.
I've seen 3%.
If you use X% of the original work or less, then it's okay. No. It may be, it may not be, but just because you haven't used that much is only one factor. How much have you taken? It's okay if you cite the source.
No, that's plagiarism.
That's plagiarism. We've talked about that before. I love this one, too. I don't know how many times I've heard this. Well, I'm not making any money.
Yep, that's one of the 4 factors to be considered in conjunction with fair use.
It's not the only factor. You can still infringe a copyright, and it can still not be fair use, even if you're not making any money.
Yep, and you still got 3 more. So keep in mind, you've got 25% of the argument effectively falls in your favor. 75% has still not been decided.
And even then, I'm not making any money. It could still be a commercial use.
Yes, it could be.
Yeah. So I see this a lot. I found it on Usenet, so it's public domain.
The argument of things being public domain on the internet is one that you bump into a lot. And I think one of the real problems that you get into with that is the internet makes it very easy to copy. You can download images, you can just do stuff, whatever you want.
And very hard to enforce. So people just assume if it's out there and nobody's had it taken down, then it must be okay.
And there are definitely sites out there that are purposefully sort of set up licensing schemes where, hey, if you want to download it for this purpose, it is okay. That's because they have a user license agreement in the background. They have something specific with it. But I think that there's a lot of idea that the internet is free and everything on the internet is free. And that's far from the truth. And I think that may be one of the biggest urban legends that's out there is the sort of because it's on the internet, it's public domain. And the answer is no. Because it's on the internet, it's published. That doesn't mean it's public domain.
A related one is, I got it from a friend of mine, and so if anybody's in trouble, he is. Well, it depends on what you do with it. Like if your friend sends it to you, that doesn't give you any copyright rights that person didn't have. So I guess if somebody sends you something and you're just like, I don't want that, and you just delete it, then you're probably okay. You haven't done anything. And you can't
never made
stop
a copy,
somebody
so
from
one of
sending
these
things
issues
to
is
you.
the copyright there.
Right, but if you take the position that because I got it from somebody else, I can just blame them for anything. No, you're still responsible for your own actions.
Yeah, and again, part of it's where are the copies made there. The person may have made a copy and sent it to you, so that's their violation. But when you have that copy, what do you do with it? Do you use it for public display? Do you do these things that are prohibited for somebody other than the copyright holder, one of which is making more copies? There's other ways you can infringe. Again, I think the public display is the best example. If I take it and get it from a friend, then I public display it. That's my infringement. I'm the one who public displayed it.
Exactly right. This one actually is not complete mythology. I see this a lot. I can make a backup copy for my own records.
Yes and no.
Yeah, I think this is one that I think you're rarely going to be challenged on, and it's probably moot in most cases. This usually applies to software, but virtually all software license anymore include an express. You can make at least one backup copy for archival purposes.
And that's really the key there. This is not a fair use defense. This is not saying that I'm entitled to this because of fair use. Most software licenses, I wouldn't say all, but I think most software licenses specifically allow you to make backup copies. What that means is that yes, there is protection in conjunction with it. Now, there is also under the Digital Millennium Copyright Act certain things you can make archival copies of based upon specific exceptions in the act, which say you're entitled to do that. The issue with it is those are narrower than a lot of people think they are.
I suspect software licensors include the archival right. I suspect because they want to carve out fair use and say, we don't want you relying upon your fair use rights. Okay, so we got a couple more fun ones. I love this one. The infinitely renewable pharmaceutical patent. If you've seen, it's in like I've seen the New York Times. It's not the New York Times. I've seen reputable news sources publish things talking about pharmaceutical patent renewals.
Yep.
There is no such thing as a patent renewal.
Yep,
it lasts for a certain amount of time and it expires, and there's no way to extend it.
Now, there is a maintenance fee which has to be paid to get the full term. Those have to be paid along the course of the terms.
But that's the opposite. You're not even going to get the full patent term unless you pay more money.
The key thing to keep in mind about a patent is that when a patent is filed, anything that issues from that patent has a term which is 20 years from the date it's filed, period. It cannot be extended. Now, it can expire early if you don't pay maintenance fees or something along those lines. What these people are usually talking about is a sort of lack of recognition of moving technology. What it is that people will potentially get a patent on one thing, And then what they'll do is they'll patent an improvement, but as a commercial product, we don't necessarily see it moving from the original to the improvement. We simply see a continuing product. It sounds like it's been renewed. The answer is no, it hasn't, because the underlying first invention is actually no longer covered by patent potentially, even though the second one is. It's just from a commercial point of view, nobody cares about the first one anymore.
Well, in pharmaceuticals in particular, you may have like a minor improvement that's separately patentable.
Yep.
Well, now everybody wants the slightly better drug, but nothing stops a generic manufacturer from making the original.
Yep, and this is done all the time. I mean, you walk into Walgreens and find any drug with "wall" in front of its name, and those are essentially generic versions of something whose patent has fallen. Now, they may not be exactly the same as the commercial product on the market. They are exactly the same as the commercial product originally exists. They have to be, essentially by definition under the FDA and the rules for generic drugs. But a key to keep in mind is that just because it says it's a generic version of X doesn't mean that it's actually a generic version of Y, which is a successor to X.
How about this one? I got in a big argument on the internet with somebody about this. So an oil company supposedly bought the breakthrough patent for the electric car battery technology so they could bury it and prevent anybody else from producing it.
I love these when people sort of come up and do these comments about the idea of buying patents in order to destroy the technology.
You can't bury a patent, first of all.
It's impossible. And the thing to keep in mind about patents, by definition, if a patent has been granted, so if there's a patent out there, the disclosure of the patent is in the public domain.
That's what the word patent means.
Yeah.
Patent versus latent.
Yeah, it's not even covered by copyright. You cannot cover a patent document by copyright. So basically, if I go out and I draft up a patent application, I file it with the patent office, and it issues as a patent, the physical patent document is not copyrighted. I can make copies of that for all I like, and that's by statute. What you bump into and what these people are basically saying is they buy up the patent and prevent other people from doing it in the patent term.
Yeah, so they basically they were saying, I bought the electric car battery technology, I'm big evil oil company X, so that I could never produce it myself, and since I own the patent, I can stop anybody else from doing it. Here's the problem with that theory. This patent was not renewed. The maintenance fee was not paid.
That means at this point in time, that invention
can do it.
Is truly public domain.
Yeah.
If somebody wants to, and I tell people this every so often, if you want to go find something fun to do, like just, you know what it is, go raid the patent office, go look in the patent office, go back in time to patents that are 30, 40 years old. Anything which is in those patents, for the most part, you can freely build, and nobody's really going to be able to stop you. Now, you can't necessarily modify it because somebody may have gotten a patent to the modification, the sort of things we were talking about here. But you can freely build these things because the patents have all expired. It's actually interesting when you talk about the idea of using the patent office's technology. One of those great things, whether urban legend or not, whichever way you want to sort of look at it, supposedly one of the things that actually happened at the end of World War II was actually the looting of the German patent office in Berlin, which actually originally occurred by the Soviet forces because they got there first, and was promptly followed by the Americans. To follow up with that, one of the things that they know was looted, supposedly from the German patent office, was the design of a circular winged aircraft. So basically an aircraft which used a circular wing in order to provide lift. Why is this interesting? Because experimental test aircraft from other countries are tested at a place in the United States called Area 51. So
you may have heard of it.
There is a pretty good argument that actually what potentially was seen as a flying saucer in Area 51 is actually a German experimental warplane looted from the German patent office.
Let's talk about ownership myths. This happens with software engineers a lot. So, my company doesn't own what I wrote because I did it after hours on my personal computer.
Not necessarily.
Not necessarily. Conversely, my company does own it because I wrote it during work hours on their computer.
Not necessarily. Now, the one thing about that is there's a special thing in conjunction with patents called shopright, which is that basically if you use an employer's resources in the course of developing something, they may have rights in it.
They have a license
at least. Patent, it's a license, a special form of it. One of the things to keep in mind that there is some right there, and it's very specific and has kind of situational type thing. You have to discuss what exactly it means.
I like this one. I had someone argue to me once that they wrote an online game based on an existing code base, but since they had changed every single line of code, they no longer were subject to the license for the original code base.
That sounds like to me that what they did is a really, really expansive derivative work.
Yeah.
The question with it is it a transformative fair use? or not. And we're back to that place again.
And with software, it's particularly difficult because sorting out what is sans affaire versus what is actually original and creative in software is difficult. You know, if you write a quick sort, there's virtually no IP in that because the algorithm's known. You can't copyright an algorithm. That's a process, and the expression to implement it is necessary and rudimentary. There's no way around it. So let's do one more. I like this. Things you can't actually patent. Another ignorant argument I've gotten into with people. Some evil company owns a patent for the human genome.
Nope,
nobody does.
It's actually, as the AIA, there actually is a specific prohibition to patenting human beings in the AIA. It's one that you pop up occasionally, just even as a patent prosecutor in today's world, they'll occasionally come back and say what you've written is effectively patenting a human being. It's usually the actions of a human being is what they're saying you patented.
Well, not to mention there's a bunch of exceptions to patent eligibility. Naturally occurring phenomena are not patentable.
Namely the human genome, which is presumably naturally occurring.
All right, well, we're running along here, so we're going to wrap it up. What is our next episode? Our next episode is the episode 8 prediction episode.
So we're going to actually create some urban legends as to what we think is going to happen in episode 8. We're also going to potentially talk about other sort of Star Wars, related things associated with Episode 8. I'm sure we're going to be, dissecting trailers. We're going to be talking about the potential new trilogy by
Somebody
the same
was asking
director.
us why we talk about Star Wars so much. It's because it's going on, basically.
Yeah, I think a lot of the reason we do talk about Star Wars so much is because, one, I think Star Wars has become a little more pervasive culturally.
Did you see, by the way, that they just announced a new trilogy?
Yep, that's what I was just talking about. I think we're going to talk about that a little bit next episode, just because of the fact that it's the same director.
Yeah, is it Ryan Johnson?
I think that sounds right.
I think, yeah.
Same guy who did 8, and apparently they're very happy with his work, so that's the reason why there's going to be this trilogy that may bode well for Episode 8. It may not. We'll see.
Yeah, we'll see. Well, and then I've been watching Star Trek Discovery, too. I've not caught up with it, but I don't know. Kirk, you've been watching that one?
I haven't watched Star Trek Discovery. I have this problem of not having most of the sort of cable or online systems. I mean, as bad as it is to be a geek, I can't watch Netflix.
Well, that's why I made him buy the Stranger Things DVDs and told me he has to watch that.
Yeah, so we only have season 1.
So next time, we're going to talk about Star Wars Episode 8. If you have ideas, predictions, or craziness you want to propose, send it along. We'll talk about it. So if you have any questions, you can ask us on Twitter at LGGPod. You can email us at lggpodcast@gmail.com. You can talk to us on our Facebook page. Search for Lawyer's Guide to the Galaxy, and you will find us. If you like what you hear, give us a review. We really appreciate reviews. It helps other people find us. It helps us with SEO, and it helps us talk the powers that be into giving us more money to keep doing this.
Yeah, so the more you tell people that you like this, the more we are likely to keep doing it.
All right, so we have the music. It's time to go. That is the official LGG podcast band, Lorem Ipsum and the Scriveners. Lorem, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded at Cool Fire Studios in St. Louis, Missouri.